and then we'll see how much the rest of this we can go through. The first item that I have for us, and I got to find the right resolution, is on the consent agenda. And so what I have, moved by Councillor Bocek, seconded by Councillor Cooper. Be it resolved, the council adopts the consent agenda of October 12th, 2021 as circulated. Does anybody want an exception, or are we going for it? All those in favor? Oh, sorry, Councillor Cooper, you're raising your hand. Councillor Wanko, you're raising your hand. So Councillor Cooper first.
I'm just making note, as I did just before we broke, that there's an item going into closed session.
Yes, that's
okay.
It will be included in the resolution when that one gets read, but you're gonna have to wait half an hour for me to prove it.
Fine.
Probably more. Okay, Councillor Wanko, did you want to have no? Okay. So I'll try one more time. Moved by Councillor Bocek, seconded by Councillor Cooper. Be it resolved, the council adopts the consent agenda of October 12th, 2021 as circulated. All those in favor? And that is carried. So that takes care of a bundle of things. And so then we are going to move, we're going to skip over 10A because we're going to do 10A as of 2 o'clock. And so I think the other thing we have to do is 11A bylaws, alternative vote methods. Ms. Way, I believe you want us to say it's okay to do something other than show in person to vote.
Correct. This was brought forward to council in June, but I just need it via bylaw. Council agreed to do it in June, so I'm hoping no one's changed their minds. But this is just us rubber stamping the process, basically. But the report back in June was the main discussion.
And you have to do this every time. In other words, this is not something that we put in motion. But every election you have to confirm this?
Technically, you could have a bylaw that's longstanding, but then you would still have to bring back a report. I would still have to bring back a report every time to council anyways.
Oh, okay.
So.
All right. So the resolution is on page 130 of 133 and page 131. Does somebody want me to read it in full, or have you read it all? Councillor Cooper.
I just have a question.
Please.
If you don't mind, Karen. Cole's notes, what are we approving? I've read it, but I'm not sure I know completely what are we going to be using electronic voting methodologies or phone in and or phone in, or what?
Internet and telephone.
Internet and telephone, so there's no in person?
Not to vote via paper ballot. So I do plan on having a help center of that effect, but this is because the actual method in which the person is casting the ballot is electronic. Same as what occurred in 2018, yeah.
Yeah, that's what we did in 2018. People would show up at the office or whatever, and you'd help them with the computer. And
yes,
is that correct?
Yes, absolutely. Yeah.
Thank you.
The libraries were very helpful at that time, if I recall.
Yes.
Councillor Hazelton, excuse me, Councillor Hazelton, I think I saw your hand, and then followed by Councillor Bocek.
Yes, thank you. I just wanted to ask a question on point number 2. It talks about the clerk established advanced votes for the 2018 municipal election. I'm wondering, is that supposed to be the 2022 election, or that's?
Yes, it is.
Okay,
sorry.
Just so that we don't roll back in time. Thank you.
All right. Do I have to make reference to that minor thing, or okay? Councillor Bocek.
Thank you, Mr. Mayor. Karen, we talked about this back in June and discussed it at length. That was during a full swing pandemic. there's been changes made on the federal level and on the provincial level for in-person election. And we voted at the community center, the Baxter Ward Community Center in the federal election and for the provincial election. Why would we not continue that practice as well as the internet and phone in?
Because it's going to cost us a lot more money to run both types of voting methods. So we can still have a help center. We can set up a help center with tablets or computers or whatever device and help people vote. But similar to 2018, there was no paper ballots to be cast.
Mhm.
And the federal and provincial governments have different regulations when it comes to their voting.
Thank you. I'll take that as it is, and I'll do a little more research myself. Thank you.
Any other comments on the voting bylaw? I have moved by Councillor Douglas, seconded by Councillor Hazelton. Be it resolved that hereby, the council, I presume, council hereby enacts bylaw 2021-066, being a bylaw to approve the alternate vote methods. Or is that the township? I'm missing a word. Okay, be it resolved that the,
Council, yeah.
sorry?
Or just be resolved that council hereby enacts bylaw.
Okay, be it resolved that council hereby enacts bylaw 2021-066, being a bylaw to approve alternate vote methods. All those in favor? And that is carried. All right. Have we raced through this so quickly? Is there anything else that we can do on this agenda before we go into the 2 o'clock presentation? I think we've covered everything. I'm not hearing anybody say yay or nay.
I don't have anything further other than
Yeah.
10A and then closed session, but I don't think there's enough time for us to go into close to come back out for 2 o'clock.
That was going to be my question. So having done this and called everybody back, are we now taking a 20-minute recess because we have to wait for the 2 o'clock to start? Ms. Gumby, are you of the opinion anything we could get done and closed before 2 o'clock, or do you think we should just take a recess and wait until 2?
I would like to be able to do, we can either do the building one or the planning one, because no one's coming to those except for staff.
There's a matter of the different Zoom links as well. And if I close this meeting, I can't get back into
Okay.
it.
Okay, well then I'm just going to apologize to everybody and say, let's reconvene in 15 minutes again. You got a break.
Mayor, if I could just advise Councilor Jarvis that he's lost, but I'm sure he'll find his way. Thanks.
We'll be hopeful.
I'll take it under advisement.
Are we returning into closed session or into open session?
No, there's an open presentation that has to precede closed. So it'll be an open at 2 o'clock for a short period of time and then going into closed. At least I hope it'll be a short period of time.
So we're not logging out, we're just going away.
Yes.
Thank you.
We're just going away.
Yeah.
Cody? Can I have a question for you?
Hello, can you hear me?
Yeah,
Yep,
you did
good.
an inspection at that Taylor Cottage last week about all that tree cutting. Everything okay there?
Which property was that, sorry?
Oh, one on the 6 Mile Lake where all those trees were being cut down on that property. Everything okay over there?
Right, I did do an inspection. I think it'd be best to touch base offline here.
Yeah, we are being
Sure.
recorded at this time.
Oh, okay.
I could send you an email following the meeting here.
I wouldn't mind. Thank you.
Ms. Way, is Mr. Kemmerer going to be, is he present?
He is not in attendance at this moment.
And we're expecting him by 2, I believe.
Yes.
Okay. All right. So, council, while we're waiting, my understanding of what we need to do now is that in open, we will allow a presentation on behalf of the applicants, lawyer, I believe, or counsel, and then we'll go into close to discuss it, simply because this is a legal matter and our prior advice had been enclosed. Therefore, we should our update should be enclosed. However, the presentation by the applicant and their lawyer is something that apparently takes place in open. With that, one thing I should just confirm is whether or not there's anyone here has any conflicts of interest in regard to this particular matter. I don't see anyone volunteering a conflict of interest. So I guess the next thing we do is, Mr. Avery, do you have a presentation to make to us before the owner's submission?
Good afternoon. Thanks, Your Worship. Yeah, I do just have a quick, brief, verbal kind of overview of where we're at, and why we're meeting here today. So I'll go ahead and start. Essentially, the information that I'm going to provide here is regarding, obviously, the site alteration matter located at 109 Ravine Way. As mentioned previously, I'll mention again both the repair order and the review the order has been provided to council through the clerks. During the summer of 2020, the township did receive multiple complaints regarding 109 Ravine Way with respect to site alterations. Following, staff did visit the property and an investigation was launched. During the township's investigation, multiple site visits have been conducted. And further, to support the township, we did retain Hutchinson Environmental Sciences in the spring of 2021, and staff from Hutchinson Environmental did visit the property on April 6, 2021. Following the site visit inspection by a professional geoscientist and certified inspector of sediment and erosion control, the township did receive a reclamation plan from Hutchinson Environmental that included minimal reclamation measures to have the property brought back into compliance. The reclamation plan was produced for the township and included the minimal measures to be undertaken on the shoreline area. Further, based on the evidence collected, the township has determined that the owners of the property, known as 109 Ravine Way, is in contravention of the township's site alteration bylaw 2014-72. Following a repair order E20-21 was issued on August 24th, 2021 pursuant to section 7.2 of the Township Site Alteration Bylaw with respect to the lands owned by Paul and Roberta Lynn Henhofer. The repair order consists of reclamation measures A through E can be completed on the lands as recommended by Hutchinson Environmental on the reclamation plan that was produced on May 10th. The reclamation works have been directed and ordered to be carried out by October 30th, 2021, with following revegetation works to be completed on June 30th of 2022. Just one little housekeeping note I wanted to leave with here before I finished. A little bit of a typo in the repair order that Mr. Pickfield has made us aware of with respect to reclamation item C on the repair order. Essentially, it was a number typo with 750 millimeters of soil to be placed. It's actually 75 millimeters, 3 inches, to clarify. Both Mr. Pickfield made the township aware, and I believe it will be discussed later on. But in short, that concludes my brief background of the order and the matter in front of council today. Thank you.
Let's unmute myself before I talk. So the next step in this, if council has any questions of Mr. Avery suitable for open. And once we've gone through those questions, then I see that the Mr. Kemmerer, who's the lawyer for the applicants, is here, and he will make a presentation to us. Councilor Wojcik.
Thanks, Corey. In the report, it was evidence that there was a recommendation by the environmental company to do that. Did you back that up with an order to do that? Obviously, recommendations are not usually followed, but if there's an order, it would be followed. Just a bit of clarity there.
Through your worship, Councillor Wojcik. So the township did retain Hutchinson Environmental to produce or to provide the township with a report on how or measures on how to bring that property back into compliance. The measures that were provided by that report through Hutchinson Environmental were essentially the orders or the measures that were included on the order, the repair order.
Okay, but on the repair order, it was recommended that these be done. Was there any order by the township that it must be done just to get rid of the question?
So through your worship, the repair order that was issued, E 2021, is an order in itself. So under the site alteration bylaw, the township, by means of staff, have the ability to issue that repair order and set out reclamation works within the order to be done on the subject lands. And in short, the repair order that has been issued, that is before council today in a review, is in fact the order.
Great, thank you very much for the clarity.
Any other questions, council, at this time? Okay, seeing none, I'm going to hand the screen over to Mr. Kemmerer to make his perspective on this file known. Mr. Kemmerer.
Thank you very much, Your Worship, members of council. I appreciate the chance to appear before you today and to provide our perspective on the repair order. I apologize. I used a link to come into the Zoom that was incorrect, and thankfully my friend Mr. Pickfield provided me with the updated link. So, excuse me, I have missed some of what Mr. Avery said in his start, and I'm not sure my client and Mr. Jackson were going to be on this, and I'm not sure if they're on the wrong Zoom link as well. In any event, I want to start by saying that I think staff's intentions are good, you know, to make sure that environmental measures are enforced, to make sure that, you know, the zoning bylaw, site alteration bylaw are followed. In this case, however, those good intentions don't correspond to what's actually happened on the ground. And that is my client, if you will, is in a sense paying or being asked to pay for the sins, you know, in the sense of like of his predecessor owner, which is to say the owner before him, and I trust everyone on council has before you my letter of September 21st, 2021, where I set out the history of this matter. And that is that when my clients purchased the property in 2017, what they inherited through that purchase was a property that had already experienced significant site alteration. And that is approximately 85% of the shoreline had been altered by the previous owner under the guise of, I don't know if he thought it was aesthetic, but also stabilization measures, which included installing fencing, wires, logs, boulders, and other similar structures along the shoreline, but also, in a sense, taking what had been a natural state and turning it into, if you will, a man-made state. So our first problem is that the report, and I think the environmental report, took a wrong starting point, which was to say that those lands had been naturalized prior to any improvements made by my clients on the lands. They were not. In fact, the site was already considerably altered. So what happened was that my clients, even though they had a cottage which was 11 meters from the shoreline, which, as you will well know, is an attractive feature in cottage country, what happened was they submitted and obtained a building permit to remove the cottage back. Now, the previous cottage was built entirely on sand, and again, it's a fairly sandy geography there. So they demolished the old cottage, moved it the 20 meters back to actually meet the zoning bylaw standard, which is an improvement. But what happened was that, of course, now there was a void in the middle of the property where that cottage had been. So neighbors looking over would see where they had used to be seeing a structure like a building on the property, would now see a blank space. And that would, I believe, in many ways exacerbate their perception of the property, was that it had been further altered. My client, working with Ministry of Natural Resources staff, did undertake a number of improvements to the property that included addressing the ministry's concerns about shoreline erosion. And as council may be aware, it's the Ministry of Natural Resources which has jurisdiction over the shoreline, as it's a crown, it's a preserve of crown rights. And I set out in my letter of 21 September at paragraph 4 on page 2, what some of those improvements were. So, and that included adding sand to cover tree roots to replenish the beach. And that was all to prevent erosion from occurring. And so I think one of the ironies here is the repair order and the environmental report behind it seek to prevent erosion, which was also a goal of my clients and that of the ministry. And that's been achieved. And in June of this year, as staff were made aware of by ministry staff, MNRF staff advised my client, and they advised township staff, including, I believe, Mr. Avery, that the measures undertaken by my client to prevent erosion on the shoreline had been successful, and that they were closing any file on this because the ministry, which has jurisdiction over this, my client followed a voluntary compliance program that was successful. There has not been any erosion. So if the report or the order seek to mitigate or prevent erosion happening, that's already occurred through measures undertaken by my client, which were approved and inspected by the Ministry of Natural Resources. So in my respectful submission, council or the township does not have jurisdiction over that. That is the ministry's area of jurisdiction, and the ministry has confirmed that there are no problems with that. And in terms of the site alteration, as I mentioned, that was already undertaken by a previous owner. So while my client made improvements to some of those structures, he cleaned up the property and he did remove some, for example, some dead trees. I think, again, what happened was that neighbors looked over and complained because they thought that, alteration or further alteration had taken place, when in fact, under the terms and provisions of the site alteration bylaw, that was not the case. That my clients were in fact working to improve, from an environmental perspective and an erosion perspective, to improve the property. So it's our submission that the repair order is not warranted, and it's not fair to put my clients under the obligation, for example, of putting in silt fences to contain erosion when erosion has already been satisfactorily addressed. And that, again, is from the ministry in June of this past year. My clients were working with town staff cooperatively, I think on both sides, to address any concerns town staff had. And they agreed that Hutchison Environmental could come in and review the property. So they were surprised when they saw the Hutchison report took as its first position that my clients had undertaken significant site alteration on the property, when that was in fact not correct. And they were disappointed because their whole objective was to work cooperatively with staff so everyone would come to the understanding of what was actually happening on the site. Now, my clients have no desire to engage in any sort of environmental degradation to cause any sort of erosion problems. And again, they in fact worked with ministry staff to make sure that didn't happen. So again, a major flaw of the report and the order is the position that my clients undertook significant site alteration on the property, which is not correct. And even if correct, site alteration, because this had been undertaken before the site alteration bylaw was introduced, is essentially grandfathered. And my clients are disappointed, of course, that when they see the recommendations of the report, which are excessive in their view, and again, address issues which have already been taken care of to prevent erosion, for example. And in my further submission, there's an irony here in that the report would lead to further site alteration, which I don't think is the intention, but would be the effect. And so, for example, it states that the entirety of the subject property would have to be regraded within the full 15 meters of the high water mark, which would be a different grading than had occurred prior to my clients purchasing the property, and would result in a site alteration under the site alteration bylaw, which isn't authorized by that bylaw. It would require that new structures be installed. And the ministry has expressed no concern with the existing structures in place to prevent erosion, for example. So that would result in even further exacerbation of a site alteration issue. And it would require extensive soil cover as well. And I know that Mr. Avery corrected that mistake in his remarks to council today, but certainly it was a concern to my client to see originally that 3 feet of soil were required on the property over the shore area, which again is really within the jurisdiction of the Ministry of Natural Resources. So for those reasons, it's our respectful submissions, and again, notwithstanding the good intentions of staff, that the report and the order are based on conjecture rather than science. And we're disappointed that they were issued because, again, the ministry had come out and inspected this, consulted with both township staff and my clients, and come to the conclusion that there were no environmental issues here, and that any concerns had been addressed, again, through that voluntary compliance program. So the remediation is entirely unnecessary, and in fact, in our view, unfair. And so in conclusion, and again, I'm here to answer any questions council has, and Mr. Jackson is also present and can answer any questions councilors may have, as he has an even more expansive and more extensive history of this site than I do. But first, again, any alteration of the shoreline was grandfathered as having been undertaken by the actions of the previous owner, not my client. My client simply made improvements to some of the structures on the property that had been put in place by the previous owner, and again worked with ministry staff to prevent erosion in the shoreline. And that MNRF again has no objections whatsoever to those improvements. And finally, the report is excessive in its recommendations for a remediation which has already been undertaken. We are asking that, respectfully asking that council, in reviewing the repair order, instead revoke the order pursuant to section 7.6 of the site alteration bylaw. And that would be, it's no prejudice to the township because the remediation which was undertaken in conjunction with the ministry has proved to be successful, and there is no site alteration which was undertaken by my clients contrary to the site alteration bylaw. So there's no prejudice to the township in the sense that the township's objectives have been achieved. And on the other hand, to allow the repair order to stand, particularly in the face of the jurisdiction of the Ministry of Natural Resources, would be wholly unfair to my clients and impose on them a burden, and again, a price that they would have to pay for the sins of a previous owner. So we respectfully request that this council review the order, and in so doing, determine to revoke that same order. Thank you.
Thank you very much. Council, do you have any questions of Mr. Kimmerer at this time? Councilor Rienko, I believe I saw your hand. It kept moving across the screen.
I have two questions. 6 Mile Lake, as you know, is a controlled water level lake, so the water doesn't fluctuate more than a few inches in the summertime. In your working with the MNR, how far back from the water's edge does the MNR control? That's my first question. And my second question is, did you obtain a permit to do any work or any site alteration within that 66 feet back from the water?
Well, in terms of the first question, my understanding would be that the MNR would have at least up until the high water mark jurisdiction over that. They have jurisdiction over any area, of course, with respect to, where the federal government does have a jurisdiction with respect to the waterways, and that would include the shoreline here. Not obviously the whole 66 feet, which goes onto land, but certainly along the shoreline up until at least the high water mark. And this work was done below that, to my understanding. So in terms of the area where my client made improvements to prevent erosion, that was outside of the jurisdiction of the township, in that it involved working with the Ministry of the Natural Resources in that area of the shoreline, which is within their jurisdiction.
Can I have a follow-up question? Do you
I
have
don't
a
see other hands
survey?
at the moment, so I say go
I just
for it.
want to know, does he have a survey of the high water mark on that property?
I'd have to look at the survey again. I certainly included one with, I'm just reviewing the survey I presented. It shows, there's a survey at the very end of my letter, that attached to my letter. And it would show the
Yeah, it's
natural,
there.
it would
It's
show the
there.
natural sandy beach below the high water mark, where the improvements were made.
Councilor Bocheck.
Thank you, Mayor. I don't think Councilor Wienko got an answer to his second question, so I'll reiterate it. Did the resident obtain permits either by the MNRF to work below the high water mark, or did he obtain permits from Township of Georgian Bay to alter the land above the high water mark? I think that was Councillor Wianco's question, and we didn't hear an answer.
He did not obtain a permit from the township because our understanding was that that work was undertaken in an area under the ministry's jurisdiction. In terms of a permit from the ministry, to be honest, Mr. Jackson may be able to answer that question, but certainly it was done in full consultation with the ministry. As I said, ministry staff attended on the site on a number of occasions. They spoke to both my clients and with township staff on that. In terms of
That was after the fact. If we're talking about the work that was done in the water, the question was there a permit obtained from the MNRF to do that work, or and you're saying there was constant consultation with the MNRF, but that was after the fact, after the work was done.
It was not
So-
after the fact, but Mr. Jackson can better answer that question than I will, and he can.
Thank you, Your Worship, through you. There actually was no work done below the jurisdiction mark, which is a high water mark of MNRF. They simply wanted assurances that there would be no erosion into their area of jurisdiction. And once they reviewed the stabilization efforts that were undertaken, they were satisfied that no permit would be required from them or Department of Fisheries and Oceans. Thank you.
Thank you. Any other questions of Mr. Kimmer or Mr. Jackson? I'm not seeing any. So at this point, gentlemen, thank you very much for your presentation and for the applicants for your presence as well. I believe the next step for us is to go into closed and consider this along with a couple of other matters in closed. So,
All right, thank you very much.
A resolution moved by Councillor Jarvis and seconded by Councillor Wianco. Whereas Section 239(2) of the Municipal Act 2001 as amended provides authority for councils of municipalities to close a meeting or parts of a meeting to the public if the subject matter pertains to a matter identified in Section 239(2). And whereas the Council of the Township of Georgian Bay deems it necessary to close this portion of the meeting in order to address matters under the following sections of 239(2). A, close council minutes of September 13th, 2021. B, personal matters about an identifiable individual, including municipal or local board employees, labor relations or employee negotiations, re HR update planning. C, litigation or potential litigation, including matters before administrative tribunals affecting the municipality, re 109 Ravine Way. D, litigation or potential litigation, including matters before administrative tribunals affecting the municipality, re proposed water development policy. And E, personal matters about an identifiable individual, including municipal or local board employees, labor relations or employee negotiations, re HR update building. Now be it resolved that Council of the Township of Georgian Bay moves into closed session of council at 2:26 p.m. All those in favor? All right, so I believe what that means is we exit from this one and we use a different link to get into closed. And Miss Way is nodding her head, so I might